affidavit that had to be filed yesterday was indeed found and sent on the parties yesterday. It is also uploaded on case lines at 022. All that it does, my lord, is to change the number of outstanding STBs to be installed. You remember yesterday, Mr. Marcus and I had agreed that you could be told that there were about 405,000 STBs to be installed. So that number has changed. It has gone down to 383 and 49,000 beneficiaries who are still to be provided with STBs. There is an explanation as to the discrepancies between 405,000 and 383,049, and it is because they were still undergoing quality assurance and verification process, which has now been completed. Mr. Marcus, the first applicant, will want to make submissions in relation to that affidavit, and I think he will address you first on that issue before I respond to his case. And also Mr. Mulepo for the SABC wants to file another affidavit. So I don't know whether between him and Mr. Marcus you will go first to address you on that issue. That's it, please, a comment.
Thank you, my Lord. My Lord, I will be very brief. My Lord, in fairness to my learned friend, yesterday, shortly before 4 o'clock, he informed me that the latest figure is that there are 383,049 households that still require the installation of set-top boxes. We received the actual affidavit at about 6 o'clock. But the figure is indeed, as my learned friend told me and has informed your Lordship, of 383,049 households, and that translates into 1,225,756 people, roughly 1.25 million. Well, Lord, we would wish to make two submissions. In broad terms, the first submission is about what the new affidavit does say, and the second is about what it does not say. So if I may commence with what it does say, I indicated to your Lordship yesterday that nothing short of an installation miracle could possibly achieve anything close to ensuring that registered households will get their STBs by the 31st of March. We now know, on the most generous interpretation of the numbers, that come 31 March, about 1.25 million people are going to be left behind. So, my Lord, at the very best for the Minister, at the very height of any argument that the Minister could advance, your Lordship can accept that unless interdictory relief is granted, then come 31 March, the following four things are going to happen. First, approximately 1.25 million people will be subjected to a television blackout, and those people, as your Lordship knows, are the poorest of the poor. Secondly, the promise made by the state that nobody who registered for STBs will be left behind will be breached. Your Lordship now knows that as a certainty. On the KZN principle, that is unconscionable conduct. Thirdly, the purpose of digital migration, as identified by the Constitutional Court in paragraphs 63 and 77 of its judgment, as being to transition to digital television without causing millions of people to lose access to television on the analogue switch-off date, will be defeated and hence will be irrational. And fourthly, the constitutional rights of some 1.25 million people will be unjustifiably violated. That, Your Lordship can all accept. And all of this, my Lord, on the Minister's version, is a certainty, and we submit cries out for protection from this court. Your Lordship is confronted with a textbook case of unconstitutionality on principles that have definitively been decided by the Constitutional Court. Now, my Lord, that's the best case that the Minister can possibly advance. And without repeating what I said yesterday, the actual numbers who will be affected on the admitted evidence is in the vicinity of 13 million. My Lord, my second submission goes to what the affidavit doesn't say. Once again, my Lord, and despite the lack of evidential weight, as I indicated to Your Lordship, that is accorded to bare assertions, the court is once again subjected to nothing more than bare assertions. But even if we are to take those bare assertions at face value, the most conspicuous feature of this latest affidavit is the complete absence of any plan as to how and when these 383,049 households will receive their STBs, and how this is remotely achievable by the end of the year, or how the risks which Centec identified to Parliament just 2 weeks ago will be overcome. My Lord, those risks are identified in Centec's parliamentary presentation, and I want to refer Your Lordship to what is said in that regard at 011-98. The risks identified by Centec are, firstly, the lack of available STBs. The presentation describes this risk as follows, and I quote, "Additional STBs must be procured, but this may take time and may not be available in the required time frame." That's what Parliament was told a bare 2 weeks ago. The new affidavit simply says, and this is at paragraph 2.4, that Centec is, and I quote, "currently adjudicating another tender to further expand the installation capacity." That's what it says. It is completely silent on the actual availability of set-top boxes. It's completely silent on at what stage this procurement issue is going to be determined, and indeed whether a provider or whatever it is that's under tender will in fact be achieved and on what timescale. Another risk identified on the same page, my Lord, and again I quote, "Installers are unwilling to install due to cash flow challenges." Silence on that. And thirdly, another problem which is identified was that, and I quote again, "Installer take-up in rural areas is a challenge." On none of these issues is there a single word. And, my Lord, of course, there's also no explanation to Your Lordship as to why this court or indeed the applicants did not receive this affidavit in proper time. Now, my Lord, I was informed this morning that the SABC also intends to file an affidavit, and to perhaps use a metaphor which is current in this case, at this point I am in the dark. I haven't seen the affidavit, and perhaps when my learned friends are on their feet I will look at it, and to the extent necessary I might seek your Lordship's indulgence to say something about it. But my Lord, those are my submissions on the new affidavit from the Minister. My learned friend Mr. Ferreira for MMA also wishes to say a few words to your Lordship, if you will permit it.
Yes, thank you.
Thank you.
Thank you, my Lord. My Lord, we have three very brief submissions.
Just 1 second, Mr. Yes, you may proceed.
Thank you, my Lord. My Lord, in relation to the affidavit which was filed yesterday, we have three submissions. The first is that on its face, it does not materially change any of the submissions that we made yesterday, because it now makes clear that it is common cause that 1.2 million individuals will be plunged into television blackout if ASO happens in 10 days, as is intended. And so rather than providing this court with any form of assurance that ASO will not harm constitutional rights, in fact, it confirms precisely the rights violation which we submitted is unjustifiable yesterday. So it makes no material difference to the submissions we have already made. Secondly, my Lord, the court will be aware that in an application for interim relief, the court will have regard to the inherent probabilities of the evidence before it. The authority for that proposition, my Lord, is long-standing. It goes back at least to Webster versus Mitchell, 1948, Volume 1, SA 1186, where the court said that the approach to the facts is to take the facts set out by the applicant, together with facts set out by the respondent which the applicant cannot dispute, and to consider whether, having regard to the inherent probabilities, the applicant should on those facts obtain relief at the trial. And what we say is that this late affidavit is inherently improbable, and in particular, the final paragraph of that affidavit, which tells this court that Centec will be able to complete the installation of government-sponsored set-top boxes by the end of 2025, does not stand up to scrutiny on the facts which are common cause before this court. Let me just explain to the court why I say it is inherently improbable when you look at the numbers. Centec tells my Lord that it is going to install 383,049 set-top boxes by the end of this year. There are 9 months until the end of this year, so that means Centec, in order to hit that target, would have to install 42,561 set-top boxes per month. Now, my Lord, let us look at what the historical rates of installation are. They are set out in ETV's replying affidavit at paragraph 38 at page 011-26. And what you see there in paragraph 38.2 is that in December of 2024, they installed 8,646. In January of 20, and my Lord, this is all taken from Centec's parliamentary presentation, so it can't really be disputed. They installed 8,646 set-top boxes in December 2024. In the following month, January 2025, they installed 10,293 set-top boxes. And in the first half of February 2025, they installed 8,486 set-top boxes. Remember, my Lord, they now tell this court they are going to do 42,000 a month from next month onwards, but in December, January, and February, they were in the region of 10,000. So what Centec is promising is that they are going to quadruple the rate of installations. They are going to increase installations by 400% overnight. That would be quite an extraordinary achievement if it was possible. But we say it is inherently improbable that they could achieve a 400% increase in rate of installation, given that they give this court no explanation as to how they are going to suddenly quadruple their installing capacity overnight. Other than to say that in February, this is in paragraph 2.6 of the affidavit, Centec increased the existing installer capacity by appointing 275 additional installers. Now, again, my Lord, I had a look at the numbers, and what you see from Centec's presentation to Parliament at page 011-96 is that before this increase of 275, they say, this is at page 011-96, it says, Centec has appointed installers nationally and currently has 640 installers in the 4 priority provinces, because the court will recall, as I submitted yesterday, they're only currently installing in these 4 provinces. 5 are left entirely out of account. So they have gone from 640 installers, they've added 275, which takes them to 915, and that, my Lord, is an increase of 43%. So Centec wants this court to accept that it is going to increase its installation rates by 400%. But the only thing that it has done to achieve that increase is to add 43% more installers. My Lord, even for mathematically challenged lawyers like ourselves, those numbers do not stack up. You cannot achieve a 400% increase by adding 40% of capacity. And even if you accept that the new tender was going to double the number of new installers, which is to be adjudicated sometime in March, we assume, that still only gets you to 80% extra capacity. It is still way short of 400%. So, my Lord, we submit that on the probabilities, the inherent probabilities, this court cannot accept Centec's bare assertion that it is going to be done with this task by the end of this year. The numbers do not stack up. That is our second submission about the new affidavit.
But that's arguing the case for end of the year, which this court is not seized with. You've made a submission regarding end of March,
Yes.
which this court is seized
Yes.
with. But I understand your submissions regarding the future. But
Yes.
at this moment,
Yes.
I've heard you.
Thank you, my Lord. No, my Lord is quite correct, and I don't want my submissions about what is promised by the end of the year
Yes.
to undercut the fact that it's common cause that in 10 days, 1.2 million people will be cut off. It's just that the Centec tries to give the court some assurance that it tells the court, you don't need to worry too much, because by the end of the year, we will have installed all those people who are going to be plunged into darkness in 10 days' time. And what I'm saying is that this court cannot accept that assurance on face value, but I do accept what the court is putting to me, that's not what the case is about. The case is about the blackout that is going to happen in 10 days' time. I absolutely accept that. My Lord, and the final submission in relation to the new affidavit is that even if you were to accept everything which is contained in that affidavit, as true and correct and probable and substantiated evidence, it actually counts against the minister's attempt to defend this interdict. Because, my lord, if it is possible for the state to ramp up its installation capacity by 400%, to achieve 42,000 a month overnight, then why are they only doing it now? Why are they only doing it 1 week before analog switch-off is due to happen? Why didn't they do it a year ago or 2 years ago, in order to ensure that they've kept their promise not to leave anyone behind? If they have this capacity, my lord, why is it only being implemented now? There is no explanation on that score before this court. And we submit that what a responsible constitutional citizen would do in the face of these facts is it would conclude that the only rational and lawful way to do analog switch-off would be to postpone the date to a date beyond the time when you can achieve this magnificent 400% increase and when people have actually been installed. And it also shows, my lord, that the refrain from our learned friends that it is indigent households who are to blame for the situation because they have failed to register and have failed to take care of their own television supply by failing to register rings hollow. Because what this shows is that the state has always had this capacity. There's no reason why it couldn't have appointed more installers 1 year or 2 years or 3 years ago and speeded this process up. It is the state that is to blame. It is not indigent families who are to blame. And so the complaint that we are going to have to incur some additional expense, and the reason for that is to be laid at the door of these families who have not registered on time, is one which this court can reject on its face. My lord, I've given to my learned friends a draft order which I should have handed up yesterday. There's nothing novel or exotic in it. It contains essentially the relief that we sought in the notice of motion. The only thing which is altered is the prayer for costs, which has been changed from the notice of motion to make clear that the costs are sought separately in respect of the first applicants and the second and third applicants. And it also changes what was in the notice of motion was that costs should stand over for Part B. What we submit is that in light of the state's conduct of this case, the Part A conduct, the late filing of the affidavits, the failure to make out any defense, we would submit that it is appropriate that there be costs in Part A and that there be a costs order, as both Mr. Marcus and I asked in our submissions yesterday. We've simply put that into a draft order for the ease of the court, if I may hand it up.
All the applicants, or just for?
Yes, I've shown it to our colleagues for ETV. It's a draft. It's a draft order which is submitted on behalf of all of the applicants.
Yes. Thank you.
Thank you.
Thank you, Mr. Ferrer. Is it counsel for number
Yes.
5, respondent 5?
Yes, the SABC, my lord. Yes. My lord, you'll be aware that the SABC filed a notice of intention to abide by the decision of the court. And secondly, that the SABC was present at court during yesterday's session. During yesterday's session, my lord, certain statements
It's
and
Mr. Daza, is that right?
no, Mr. Molepo,
Oh, Molepo, sorry.
yes,
Yes, Mr. Molepo.
yes. During the yesterday's session, my lord, certain statements and amendments were made about the SABC. For example, that the SABC switched off the analog in 5 or so provinces. As a consequence of those developments, the SABC felt that it should file an explanatory affidavit to explain those circumstances. And secondly, my Lord, there is a plethora of difficulties that the SABC experienced with the implementation of this particular program. And for that reason, they felt that they should put an affidavit to the court so that the court can understand the issues similarly from the SABC's perspective, more so as the biggest stakeholder in this entire program. So for that reason, an affidavit has been prepared. It has been circulated to our colleagues, and I suggest that during adjournment they consider the affidavit and advise the court if they accept that the filing of that affidavit.
Well, what does that do to the abiding status of the SABC?
The SABC continues to abide by the decision of the court, my Lord, and it is simply an explanatory affidavit and nothing more, nothing less.
I see.
As it pleases the court.
Thank you. Thank you, Mr. Molepo. Mr. Tatsawana.
May it please the court, my Lord. Lord, firstly, as far as the affidavit of the SABC is concerned, which my learned friend, Mr. Molepo, says is an explanatory affidavit, we object to the filing of it at this stage. It raises issues which will require a response from the first respondent, and there's just no time for that to happen at this point in time. So unless I'm instructed again otherwise during the tea break, we are objecting to it. Then, my Lord, as far as the first respondent's response to the applicant's case is concerned, we have prepared a summary of our argument, and we have uploaded that at section 22 on case lines. We have prepared a hard copy of that. I don't know if that is more convenient for my Lord or if we should work on the
Yes.
I mean, that's it. My Lord, as I said yesterday, this note responds to the issues which were argued before you by the applicants. The first issue that we deal with is the position of ETV, which is dealt with in paragraph 1 of the heads of argument. The issue there, my Lord, is simply to highlight the fact that ETV is not necessarily litigating in this case to protect the interests of the poorest of the poor. It is litigating in this application to protect its own commercial interests, and we'll demonstrate why we say that. But most importantly, my Lord, it was suggested yesterday that the Constitutional Court in the ETV judgment rejected the argument that ETV was litigating for its own commercial interests. We submit that on a proper reading of the relevant paragraphs of the judgment, the Constitutional Court, in fact, did not reject the argument. In paragraph 102 of the judgment, to which my Lord has already been referred, well, firstly, starting with paragraph 101 of the judgment, that's where the Constitutional Court summarized the submissions made against the conduct of ETV in the litigation. The effect of it was simply that ETV has taken different positions about analog switch-off date. Firstly, it had supported an expedited analog switch-off. And the reference was made to the telecom case, which my lord dealt with in 2021. In that case, ETV was motivating for an expedited analog switch-off. But in the case before the Constitutional Court, ETV had changed its position because it was litigating against analog switch-off. In paragraph 102 of the judgment, was the Constitutional Court said they do bear consideration. It highlighted that what was before it was in fact constitutional litigation, and it was more concerned about the lawfulness of the minister's conduct in that case, and so it didn't entertain those submissions. So it didn't then reject the argument. It just didn't deal with it. Then you were specifically referred to paragraph 106 of the judgment. But that paragraph, my lord, deals with the question of cost in that case, and the long and short of it, the court concluded that this was constitutional litigation and the by-watch principle applies. Then lastly, on this point, my lord, which we want to highlight, is what we say in paragraph 1.6 of our summary as a argument. Then, my lord, we bring to your attention the fact that when ETV was in the process of switching off the analog transmitters that had been assigned to it, there was an arrangement between broadcasters and Centre to send a message to all the analog television sets at that point in time to inform them that analog television is no longer going to be available, and this is what you need to do to be able to continue to watch television. You will see at the bottom of page 3 of our heads of argument the message which ETV requested Centec to broadcast through all the television sets. It said, after the deadline, ETV analog service will not be available in your area. And then it said, to continue enjoying your favorite TV shows and get many more entertaining channels, get an open view decoder from a retailer near you before 17 October 2022. My lord, this is not the STB box which is provided by the government. This is an STB box which is provided by ETV itself at a cost. When they did this, why is it that they didn't send a similar message to the poorest of the poor that they say they are fighting for in this application? They didn't. There's absolutely no explanation for it. And that is why we say this is more about their own commercial interests more than the poorest of the poor. And again, we'll demonstrate further evidence that that proves the point. So we submit, my lord, that if they were concerned about the poorest of the poor, then that message will also have included something along the effect that if you are unable to procure this open view decoder, which is linked to ETV, you must urgently register and procure a state-sponsored STB. But they didn't do that. And we submit, my lord, that this is an issue which the court cannot ignore, and this is an issue which the court must take into account in weighing up all the evidence and submissions made by ETV. The next point, my lord, is the issue of cabinet taking the decision. There is absolutely no contest that cabinet took the decision. The minister has said that several times. He says that in the affidavit before you. But the point is this. In paragraph 36 of the ETV judgment, the court categorized the nature of the power to determine the analog switch-off. It said it is executive in nature, and the determination of the analog switch-off date is implementation of the broadcasting digital migration policy. So what the Constitutional Court is saying there, my lord, is that when you make a determination of the date. You're implementing policy. And the question now that arises is whether or not Cabinet is empowered by the Constitution to implement policy. And the answer is yes. Then, my Lord, we refer you to Section 85(1) of the Constitution, which provides that the executive authority of the Republic is vested in the President. But then the President doesn't exercise that authority alone and by himself. He does that together with other members of the Cabinet. And the Minister is a member of the Cabinet. But he also does that, my Lord, by implementing national policy. And the BDM policy is national policy. And we submit that on a reading of that section, there could be nothing unlawful for Cabinet to implement the broadcasting digital migration policy. And my Lord raised a question yesterday about whether or not it may not have been influenced by the nature of the decision and the impact of it. And the answer must be yes, because we have said over the years, the government has incurred over 1.3 billion dual illumination costs. And if the relief that is being sought in this application is granted, that will require Cabinet, the executive, and Parliament to find money to continue to find dual illumination, which were fully addressed in our main heads of argument. So we submit that it was correct for this matter to be dealt with by Cabinet. And lastly, on that point, my Lord, we refer you to the judgment of the Supreme Court of Appeal in the case of Isau versus Minister of Cooperative Governance and Traditional Affairs. The essence of it, my Lord, is that the Cabinet is free to determine how it functions. They are free to arrange their affairs in the manner in which they deem fit. And there could be absolutely no suggestion that they didn't know what they were doing when they dealt with this issue. We know from the record that they dealt with it twice in December. The first instance, they refused to postpone the date of 31 December 2025. It was on the second occasion that they then agreed to postpone the date of 31 December 2024 to 31 March 2025, which is the date which is now in dispute. So we submit, my Lord, that on a reading of what the Constitutional Court said in ETV judgment and Section 85 of the Constitution, the President, together with other members of the Cabinet, were perfectly empowered to determine the date. And therefore, there is absolutely then no merit in the suggestion that the Minister abdicated his powers, a Cabinet usurped his powers. They did it. It's provided for in Section 85 of the Constitution. That, my Lord, then deals with that point. The next point.
Section 85 of the Constitution.
Yes.
Is dealing with more the powers of the President in relation to the Cabinet, isn't it?
Well, it deals with this executive authority.
Yes.
What it says.
Yes,
Yes.
the executive authority of the President.
Correct.
What I'm seeking to understand from the submission in that regard, I think I don't have Mr. Marcus's reference document, but he refers there to no less than 3 cases, and which are specific about the decision maker.
Correct.
Making the decision.
Yes.
And putting the first respondent in a position where in his answering affidavit he cannot say the Cabinet made the decision. If he's stating things correctly, says, I made submissions to the Cabinet after having decided the matter in this form, and then there is no obfuscation around who took the decision. But when the decision maker, under oath, says the cabinet took the decision, what can you read into that? Are you supposed to decipher it to a point where you say, well, he says so, but actually he made the decision? You can't. That would be misreading what is stated under oath by the minister when he says that. Am I incorrect in my understanding?
Well, I'm not sure I understand my Lord's point, but what is common cause in the pipe, and this is also what the minister says, is that the cabinet took the decision.
Yes. That's what I'm saying.
Not the minister.
Yes.
And the criticism is that the minister is the one that is authorized by the policy to make the decision.
Yes.
And that he didn't do it.
Yes.
And because he didn't do it, what cabinet did is unlawful, basically.
Yeah.
That's the issue.
Yes, that's the submission.
Correct.
that
Yeah.
I-
Yeah. So our answer to that, my Lord, is that it was not unlawful for cabinet to take the decision, because Section 85(1) does empower cabinet to implement national policy. And in ETV, the court correctly said the determination of the date of analog switch off is implementation of policy. That's our submission. And that is because the executive authority, which the president does assign to ministers from time to time, is vested upon him. But he exercises that authority together with all the other members of the cabinet, including this very minister.
But is this issue not also dealt with by the Court in the ETV decision, where the Court was also quite clear about who makes the switch-off decision?
Correct.
What does the Court say?
Well, it said that that is the minister's decision to take.
Yes.
But this particular point was not before the Constitutional Court at that time. This is now raised in this issue because the minister says the cabinet took the decision.
No, Mr. Tsatsawana. For you to say this point had not been raised in this manner before the Court, the Court was quite clear and specific that it's the minister's decision, isn't it?
Correct.
So once we are correct about that, it clarifies then the submission by the applicants that it was unlawful for the cabinet to take that position. I'm now no longer referring to Section 85. I'm
Yes.
referring to the Court decision, because
Yes.
there's a clear contradiction there. And the contradiction is caused by the minister's assertion in the answering affidavit that the cabinet took the decision. I hear your explanation,
Yes.
which is virtually deciphering what happened there, because it could still have been stated clearly by the minister that having taken the decision that this is going to be the date of switch off, and having briefed the cabinet as is my duty to do so, when I take decisions, the cabinet also approved or endorsed or whatever.
Yes.
Then there'd be no confusion about
Yes.
it. Yes, and I wouldn't be referring you to the Court to say, no, you are deciphering it in a manner that suits the first respondent by saying, well, this is implementation of...
Yes.
Yes, it's simply that I wanted to hear you on,
Yes.
on that.
Well, my Lord, I think the answer to that is that if there wasn't some other empowering provision for cabinet to implement national policy, then it would have been unlawful altogether for cabinet to exercise that power. But there is that provision in the Constitution. And we submit that they were perfectly empowered to act in the manner in which they did because of that particular provision. If that provision was not there, then we probably would have dealt with this case differently, because we would then have been bound by what the Constitutional Court said. But as I said, the Constitutional Court did not have to deal with whether or not cabinet could actually exercise this power, because in that case, it was the minister who made the determination, and there was no dispute about it. What was the issue was the nature of the power that the minister exercised at the time.
Yes, and lastly on this point,
Yes.
Doesn't even the digital migration policy confirm who the decision maker is?
Yes.
Who does it confirm?
That's in, I think in paragraph 2 of it, it says the minister will make the determination.
Yes.
Yes, that is correct. But it doesn't exclude cabinet from doing it, particularly when the minister takes it to the cabinet. And he goes to cabinet and he says, this is what has been happening with the digital migration process. Now I'm putting this before the cabinet for cabinet to take a decision on the final analog switch of data. That's what the minister says. He says, I briefed the cabinet, I told them what processes have been followed, and then I went there for a decision. He went there for the first time to ask for a postponement, and cabinet refused. Then he went back again for the second time, and that is when cabinet agreed, because he took it to the cabinet. The cabinet did not just one of the days decide to take this decision. The minister took it there for that purpose, and that is when the cabinet took the decision.
Yes.
Yes.
Thank you. I just needed to hear you.
I said, please, the court. Then the next point, my lord, is the question of consultation. We deal with that, my lord, from paragraph 3 of our argument. This is a very hotly contested topic in this case. And we submit, my lord, that it is wrong to look at the consultation point only from the time that the deadline of 31 December 2024 was then postponed to 31 March 2025. One has got to look at what has been happening before, what the parties have been saying to each other throughout this process, because it is important to have regard to what ETV and the other two applicants have been saying to the minister throughout what we say is the consultation process. Firstly, my lord, we will refer you to the electronic media case judgment, because it sets out what the purpose of consultation is. And if the purpose of consultation has not been achieved, then you can conclude that the process was unlawful. In paragraph 3.2, my lord, we made the submission that the purpose of consultation is to solicit the views of stakeholders on the subject matter of the consultation. In this case, the subject matter of the consultation is the analog switch of data. That on its own, my lord, involves the registration of indigent people. It involves the distribution of STBs and everything else. What then arises, my lord, is whether the applicants were given an opportunity to make representations on these issues. And we submit, my lord, that they were given opportunity and they exercised their rights to make a representation. Not once, but many times, as we will demonstrate to you now. The first notice, my lord, came out on 9 December 2022, and it requested interested parties to make submissions. 9 December 2022.
But clearly, that's not about 31 December 2024.
No, well, my lord, that actually now takes us to that particular date, as I will demonstrate to you now. So if you give me a moment, I will show you how everybody arrived at 31 December 2024.
I'm not sure why I'm asking you, even as you enter that
Yes,
that period of this consultation
Yes.
issue. Why I'm asking you about it is because unless you are saying that notice was addressing 31 December 2024, which is impossible,
yes,
but I'm sure you're going to clarify that.
I'm going there.
Yes.
Yes,
And why maybe I'm raising it even at this stage with you is because I'm not sure if the applicants are challenging that part of the consultation. This is why even yesterday in addressing Mr. Marcus, I referred to the consultation process that starts in June 2023
yes,
and suggested to him that that's an example of what consultation means,
yes,
as I understand it. And he
Correct.
agreed with me
Yes.
that yes,
yes,
it was indeed quite an extensive process that went through various stages and so on and so forth, which
Yes.
because it's not being contested.
yes,
Now, to plug that process and fit it, I'm not suggesting you're going to do that, but I have a sense that's where you're going,
yes,
to demonstrate the consultation process is inappropriate because that was about about the decision which led to 31 December 2024,
yes,
that process of
Correct.
June.
yes.
So I'm trying to suggest to you, or for your consideration, that there is no quarrel about that. In fact, they set it out because they're showing this history and so on, until we get to the challenges around 31 December 2024,
Yes,
and when they start suggesting that this is not going to work, this is not going to work, and that in that regard, there was no consultation process. There are letters which ETV writes to the minister.
yes,
You are aware of requesting this. And even when the minister invites them around the 20th of December to brief them
yes,
about what Mr. Marcus referred to as a fait accompli,
yes,
there's no opportunity. It's like telling you this is what has happened and that's it. And he says, I have a plan. He doesn't give them a copy, doesn't. And there's hardly any time because even the invitation has been very short to the stakeholders to make any representations.
yes,
And there's none that happened as a result thereof. What I'm getting to is that this is the bone of contention as I understand it.
correct,
And taking previous and saying, no, they were consulted. There's no denial by the applicants that they were consulted at that time. And they even reached a decision, a consensual decision regarding 3112. So why do we have to go through that?
well, because the road to 31 December 2024 started on 9 December 2022. That's when it started. It didn't start in December.
Which is not contested. That's what I'm saying.
Yes, but I want to show you, because this is my client's case, that all the issues in respect of which they had to be consulted on, they were consulted on throughout this period. And that consultation process, my Lord, was commenced by the notice that was published in the Gazette on 9 December 2022, inviting interested parties to make submissions the following year in 2023, in January 2023. Then they made submissions, because at that point in time, the minister intended to proclaim 31 March 2023 as the final analog switch-off date. So everybody received the notice. Everybody makes submissions to the minister. The minister responded to ETV and the applicants on those issues. And in their submissions, they are telling the minister, importantly, the following issues. One, the registration process was unlawful. But at that point in time, the registration process had already passed because that was the previous year. Two, they said 31 March 2023 as final analog switch-off date is not achievable. You should not do it. So you can then accept that at that point in time, both parties had told the minister their views about what concerns they have with the proposed analog switch-off date of 31 March 2023. In the minister's responses to ETV and the other applicants, if my Lord has regard to paragraph 3.5 of our short heads of argument, the summary that we gave you this morning, we have summarized what they said. They said the deadline for registration was unlawful, but they didn't challenge it. Secondly, they said the date of 31 March 2023 was not achievable. But then, my Lord, in paragraph 3.6, we have given you the references to the minister's responses to those submissions, still in March 2023. At that point in time, my Lord, the minister didn't agree with it. The minister said, no, I'm carrying on. But that, what then happened after that? Because my Lord will remember that these are not the only parties that the minister must consult with. The minister must consult with everybody else who makes a representation. Then the minister then consulted with the state entities that must now implement this analog switch-off date, such as Centec, USASA, ICASA at the time. And he became convinced that 31 March 2023 is not doable. And at that point in time, the issue of the date, why it was not suitable, was canvassed by both parties, left, right, and center. The issue of the registration of indigent people was canvassed by the parties, left, right, and center. Everybody had their chance to do it. And then the minister then agreed that this date is not good, I will postpone it. But then, there is a process that leads to that postponement to 31 December 2024. Because my Lord will remember that when you invite people to make submissions, you must consider them and then decide whether or not you agree with what they're saying or you don't agree. So at that point in time, then consultations took place with the parties. And then that is what then led to the 13 June correspondence. So at that point in time, in June 2023, the date which the minister had in mind had already passed because he had 31 March 2023 in mind. Now he's convinced it's not doable. And then he says, where do we go from here? That's when the consultations took place. These consultations, my Lord, led to a recommendation being made to the minister to do the process in two phases. We deal with that, my Lord, in paragraph 3.8 of our heads of argument. And we have quoted very briefly what the minister's letter says, and we've given you the reference to case lines where you will find the letter. But what is important, the minister recorded that after having noted your feedback and considered your inputs from various meetings and workshops regarding the analog switch-off approach, the department has resolved to adopt a two-stage approach towards analog switch-off, and the two phases are then set out in the minister's letter. Page 010-242. We have referenced it in our summary. So then, there's another workshop that is held in June state, and this is the consultation process where MMA and SOS say we were excluded, and they complain bitterly about their exclusion from that process. But we will tell you why they were excluded. And the answer is simple. You only need to look at the participants in that workshop. It was state-owned entities such as USASA, ICASA, Centec, and the department itself, and the SABC and ETV, which are broadcasters, and then community television stations. Those are the people who were parties to that June process. Because you must remember, MMA and SOS had already made their submissions on the point. They had already told the minister, this date is not doable. And the minister had agreed. But now he's finding ways now to proceed with the process, because the fact that he agreed doesn't then mean that the process must stop. Then I must refer you to the workshop report, which my Lord will find on page 010-230. We deal with it at paragraph 3.9 of our heads of argument. There we say that the purpose of the workshop is set out. It is recorded that the minister convened a steering committee to advise him on the way forward. And then, my Lord, paragraph 3.9.3 is very important because it records what the national broadcasters said during that workshop. And the national broadcasters that we're talking about here is SABC and ETV. It is recorded that they contended that households that are relying on terrestrial reception are above 4 million, and only 1.5 million of their targeted audiences have registered for government-subsidized STPs. And look, you must have regard to what they say. Their targeted audience have registered only 1.5 at that point in time. So again, this is a clear indication of what it is that they're after, is the targeted audience. They were concerned that there's 4 million out there on their calculation, but at that point in time, the records reflected that only 1.5 had registered at that point in time. They were concerned about it. Then 3.9.4, we record the arguments that were made during those two workshops. There were arguments about how long the registration period has been open for applications, and the broadcasters' aspirations of having everyone registering and converted being too optimistic. So at that workshop, these were the arguments that were being put up, that this whole issue that you're going to have everybody throughout the country registering is too optimistic. And you now know why, because on their projections, there were 4 million of them. 2023, only 1.4 million had registered. And then we say, in addition, public broadcasters highlighted at a minimum, and this is important, they're highlighting a minimum migration of 2.5 million households could be satisfactory for their business sustainability. So this is what they're saying to the minister's people. They say, if we can just get 2.5, we will be okay. So this whole issue of 8 million and 12 million, it was not an issue at that point in time. They were happy with 2.5. So then the second key submission that is made, my Lord, in paragraph 3.9.5, it is recorded that the second key submission from broadcasters related to the impact of COVID, economic decline, and impact of load shedding on their businesses. And they felt that they needed a breather period to recover from these conditions before a full ASO can be implemented. There again, they are not saying, get everybody an STP. They're saying, just give me time so that I can recover from all these terrible issues that have happened. Once again, my Lord, they are making submissions on what is important for them before you decide on a date. We now know COVID was one of them, or the impact of it, and the impact of load shedding. And these are issues that are being considered at these workshops. Then lastly, paragraph 3.9.6. And again, my Lord, this is very important. They say the broadcasters have committed that there will be no further variation to the proposed plan, even if the registration and subscription do not reach their aspiration levels. At that point in time, it was only 2.5 million. That's what they hoped to get. But at that workshop, they agreed that this process could go ahead even if you don't get to that level. And then that is the process, as you will see in paragraph 3.9.7, which then led to a recommendation to the minister to say 31 December 2024 is the ultimate date. And again, we emphasize in paragraph 3.9.7 that even if the registration and subscriptions do not reach 2.5 million cumulative household registration level, notwithstanding all efforts by all stakeholders, they were happy with that at that point in time. But even if we don't get to 2.5 million, the process must continue. And lastly, on this point, before we go on the tea break, my Lord, is the attendees of the workshops who are listed on page 010-237 and 010-238. We say ETV and the SABC attended the workshop, whereas the second workshop was attended by community broadcasters. So there were two workshops, one which included the national broadcasters and another one which included the community broadcasters. And that is why MMA and SOS were not at that meeting. And you can see from the contents of the debate during those workshops that the issues that they were talking about were issues which were very close to the hearts of the broadcasters. So, my Lord, I think it is the right time to take the tea.
Well, before we go,
yes,
to my point,
yes,
there is no contestation about what you've gone through.
yes,
That records indeed what happened.
correct.
But demonstrably, even from your quotations, the issues there are different. For instance, on your 3.9.5,
Yes,
broadcasters relate to the impact of COVID,
yes,
economic decline and impact of load shedding on their businesses. They were different from what could have been considered about 31 March 2025. Now, if when we come back, you can show me where a similar consultation process took place regarding 31 March 2025, I will be pleased.
well,
You can point me
Yes.
to the record to say
Yes.
this is where it happened
yes,
and a similar process happened,
yes,
because why I'm asking,
yes,
I'm not making light of your reference there
Correct.
too, you proving your client's case,
yes,
but what I'm asking for is for you to say, well, this is what happened then, 2023,
yeah,
and go to the record. You're going to see the consultation process regarding 31 March.
2025, yes.
25.
Yes.
And the reason why I'm saying that is because, as you've seen, the applicants are quite resolute on saying, no, we were informed about a done deal.
Yes,
There's nothing that we could have said. So they couldn't have talked about COVID regarding
Correct.
31 March.
Correct.
So if you can just take me there and say, this constitutes the consultation process regarding 31 March, I'll be pleased, because the applicants are saying zero.
well, my lord, I will take you through the evidence to demonstrate how the government arrived at that postponement.
No, I was saying you take me to the consultation process, similarly as you have done.
Yes,
Not,
yes.
not what the government did.
What, my lord, my client's case is that there was no legitimate basis for another round of consultation when the postponement was given. And I will then demonstrate to you why my client says that.
Yes.
Yes.
All right, we'll take the tea agenda.
I think please the court.
For 15 minutes.
Like affidavit.
it is important for my Lord to understand how we arrived at 31 March 2025, because 31 March 2025 did not just happen. There are events which led to it. The
Yes.
first event, which is very important,
So you are saying you are getting close to 31 March 2025, where you'll show me or you'll comply with my request.
yes, but my compliance, and I must say this up front, my compliance with your request is going to be that the minister did not have to give them another round of consultation again.
No.
And I'm happy that my Lord accepts that they have been consulted on these issues, which they say they needed to be consulted on, because that is the process that started in January 2023 when they were invited to make written submissions.
Yes.
Yes.
But now that we're saying things up front, and you
Yes.
also say, when I asked for you to lead me to that, I didn't ask whether the minister needed to consult them or not. I said, take me to where he consulted them. And if you want, at that point,
Yes.
to say, no, he didn't, that's what I'll be happy with.
Okay, so
Because you're saying up front that he didn't need to.
correct. He didn't need to give them another round. Yes. Yes.
So I don't want an indirect answer
Yes.
in that regard.
Yes. The direct answer, my Lord, is that when the decision to proclaim 31 March 2025 was taken by cabinet, the minister did not go to the applicants and say, I'm now thinking of 31 March 2025. That did not happen. That we accept. And
Yes.
our submission is that it in fact did not have to happen. Yeah.
That will be part of your argument.
Correct.
Yeah.
And that's basically the issue which my Lord has got to answer on this point.
Yes,
Whether or
yes.
not there was supposed to be.
I know what your argument will be
Yes.
from what you've said, but I just wanted to make sure I'm not missing
Correct.
information
Yes.
as you demonstrated the other information. I wanted to know I'm not missing any
Yes.
other.
Yes.
Yes, you may.
So
you
let
may
me now
continue.
take my Lord very close to how this date came about. The first point is what we raised in paragraph 3.11 of our summary. We refer, my Lord, to a meeting that took place between the minister and ETV. We have underlined there for emphasis that the purpose of the meeting was to discuss the analog switch-off date. And at that point in time, there were already issues being raised that even the date of 31 December 2024 was not good enough and it must be postponed. So this is a record of the meeting which took place between the minister and ETV. We have referred you to the relevant pages of it, 010249 and 010250. The following is recorded at paragraph 3.1.7. The ASO for 31 December was not feasible, and that the date for ASO must be renegotiated. This is now ETV telling the minister. They said this date must now be renegotiated. But again, renegotiation is not the correct process, because that is different from consultation. Because in a renegotiation or negotiations, you're seeking to get to some agreement of some sort between the parties. But that's not the position with consultation. You're not seeking to reach an agreement. You want to hear the parties what their views are in respect of the issue that you're consulting with them about. The next point, my lord, is paragraph 3.1.11 of the minute. E-Media requested the ministry to consider a reasonable date beyond 31 December 2024, as this was going to affect their business, taking into consideration that much still needs to be done with the transition. So my lord can now accept that in August 2024, ETV went to the minister and said, please postpone this date. And the reason why we want a postponement is because if you keep it as 31 December, it is going to negatively affect our business. So there you have it. They are now telling the minister the negative consequences of 31 December 2024. And they said, please find a reasonable date to which to postpone the matter. And then,
Was that inappropriate or incorrect in the first respondent's view by ETV? To
Well-
state it in this fashion.
no. We're not criticizing them for that. We're telling you, my lord, what they said at the meeting.
Yes.
And when I conclude on this part, my lord will appreciate why it is important that we go through this process, because the justification for the minister's position that they didn't have to be consulted again must necessarily take into account all of these issues that we say happened going to December. The next point, my lord, at paragraph 3.13, this is where now a reference is made to a analog infrastructure that is managed by Centec. At the aforesaid meeting, it was agreed that there is a need for switch off, as the system is too old, and that it was not the first time E-Media was informed of the switch off, and that E-Media was advised to ensure that they plan for the continuation of the switch off. So at that point in time, the minister considered what was put to him by ETV, and then he gave an answer. Importantly, my lord, we have given you further references in the record, 003-28 to 003-52. These are letters from a MMA and SOS. And in these letters, written to both the minister mainly, and I think one or so to the president, they were requesting the minister and the president to postpone 31 December 2024. And in these letters, they gave motivations as to why the date must be postponed. And we submit, my lord, that they have made representations why there must be a postponement. ETV said, just find a reasonable date to postpone this date. And the minister considered this this representation, because one of the letters ended up with a demand that you must take a decision to suspend the date pending a review application. And the minister responded as set out at the end of paragraph 3.14 by saying that your demand is impossible to deal with, because the earliest time that cabinet is going to deal with this is at the meeting on 4 December, because they wanted an undertaking the day before. The minister said, no, we're only meeting on the 4th. That's when cabinet is going to consider all these representations about the postponement. Then, my lord, when cabinet met on the 4th of December, the minister and the president, because they received the letters, they knew the issues that were of concern to the broadcasters and to MMA and SOS. And that is why we said there was no need during that small window period for another round of consultation. Authority for that, my Lord, is in paragraph 3.16 of our summary, and that is the electronic media network case. My Lord, in that case, electronic media network, the issue in dispute between the parties was the amendment to the Broadcasting Digital Migration Policy. ETV and others had been given an opportunity to make representations on the proposed amendments. And the particular amendment that was in dispute at the time related to the encryption capability of the set-top boxes. Different ministers, when they came, they took different positions about this issue of encryption. And when ministerial positions changed throughout the process, interested parties were invited to make representations on the thinking of government at the time, including ETV. And my Lord, ETV made submissions on both sides of the debate, encryption and no encryption. At some point they favored encryption, at some point they said no, there should be no encryption. And then this issue then ended up in this court, and then it went to the Constitutional Court. And one of the important issues is the very same issue that you and I are debating now, whether or not they were entitled to another round of consultation on that very issue. And this is why I said, my Lord, I'm happy that you accept that they were consulted on these issues. Because in paragraph 37 of the judgment, which we have quoted, my Lord, on page 12 of our heads of argument, I'm only going to refer, my Lord, to the underlying sections of it. The Constitutional Court said consultation, as distinct from negotiations geared at reaching an agreement, is not a consensus-seeking process. So when you consult, you're not seeking consensus. So this issue that we must renegotiate is not consultation, because when you renegotiate, you must reach an agreement. That's different according to the Constitutional Court. Then the second part, the Constitutional Court said, in other words, a genuine and objectively satisfactory effort must be made to create a platform for the solicitation of views that will enable a policymaker to appreciate what those being consulted think or make of the major and incidental aspects of the issue or policy under consideration. People or entities must be left to express themselves freely on as wide a range of issues pertinent to a policy proposal as possible. The standpoints of interested parties who want to have their views taken into account must thus be allowed to reach a policymaker. But consultation fulfills a role that is fundamentally different from negotiation, and find that occurs. So, in this case, my Lord accepts that they have been consulted on these issues. The Constitutional Court said, if you give them an opportunity to give you a festival of their views, then you have satisfied the requirement. Then in paragraph 38, the Constitutional Court said, generally speaking, where there are two opposing positions and a party aggrieved by the ultimate policy decision has had the opportunity to express itself properly in favor of each of the diametrically opposed possibilities, another round of consultation on the ultimate policy standpoint can hardly ever serve any legitimate purpose. That is why we say, if you accept, and as you do correctly, that they have been consulted on one, registration, two, the analog switch of date, three, the impact of it on them, then another round of consultation we submit on the authority of this judgment was not necessary. And even if you have regard to the letters to which I've referred, there's somewhere where they say, if you had talked to us, we would have told you that this date is not achievable. We would have told you that the registration process is bad. We would have told you our businesses are going to suffer. Well, you have had the same complaints today and yesterday. The suggestion then is that there should have been another round of consultation on the very same issue. And we have demonstrated that they have expressed their views on these issues. And The government simply just did not agree with them. And the mere fact that the government doesn't agree with them or they don't agree with the government doesn't mean that they've not been consulted. And that is, my lord, the bone of contention. Then next, my lord, is what we say in paragraph 3.17, where the court indicated that obviously the decision maker is not only consulting with one grouping, is consulting with everybody else. But important, the court said interested persons ought to speak exhaustively on any aspect. And my lord, we submit, you only need to have regard to the letters that we have referred to you now. There isn't an issue that was not canvassed in those letters. There isn't an issue that was not canvassed in the meeting. They even canvassed the issue of COVID, and my lord is asking, but why is that relevant? But it was canvassed. Then, lastly on this point, my lord, is paragraph 3.18 of our heads, which deals with paragraph 45 of the judgment. And this is an important part because it deals specifically with ETV. The Constitutional Court said interested parties, including ETV, have over the years had the opportunity to express their views and preferences on various versions of the broadcasting digital migration policy formulation. ETV has had all the opportunities it could ever have legitimately wished for to influence the development of the policy as its too sharply opposed end. We are now virtually grappling with ETV's own battle of ideas. That was the position then, it is the position now. And the reason why we say that is you must only look at the correspondence and see what they have been saying and what they're complaining about in their founding affidavit, and which you had now in argument. These issues we submit, my lord, have been fully canvassed. The next point, my lord, is what what must have been in the reasonable contemplation of ETV and the second and third applicants. One of the issues, my lord, is the cost of dual illumination.
Maybe I should ask
Yes.
the question before you get to the cost issue. Well, maybe just to be precise
Yes.
and not paraphrase what was submitted by Mr. Marcus and in his reference document, which ended up yesterday.
Yes.
You only have to look at paragraph 3 thereof, where he referred the requirements for consultation as laid down in the Constitutional Court, and he quotes the relevant paragraphs, being paragraph 48 and paragraph 51 to 52.
Yes.
And he discusses them briefly at 3.2.
Yes.
And in terms of that judgment, one of the requirements is that the consultation must be in respect of the actual date.
Yes.
And you have considered that the actual date was never consulted about.
Yes, they had it for the first time when the minister told them about it. Yes.
Yes. So clearly, that was not in compliance with the quoted paragraphs of the ETV judgment of the Constitutional Court, was it?
No, I've already said that they only became aware of that date for the first time when the minister told them about
Yes.
it.
So I'm just simply putting that
yes,
they didn't comply with that?
Well, my lord, the facts of that case are slightly different from this one, because in that case, one was not dealing with a postponement of a date that had already been proclaimed. In this case, we're dealing with a postponement of a date that had already been proclaimed at the request of, amongst others, the applicants. And I've referred you to the minute of the meeting between the minister and ETV, where they said, find a reasonable date. And the minister found, and the cabinet found what they considered to
Yes,
be
in
a reasonable
finding,
date.
in
Yes.
finding a reasonable date,
Yes.
Mr. Tsawala, I think it's, I'm not quoting anybody,
Yes,
it's common sense
yes,
that as you find the reasonable date and as you decide as the first respondent on the reasonable date,
yes,
you then decide to consult the actual date, which is what you've decided on.
yes.
That's what this judgment
That
is.
is what the judgment is saying. And,
Yes.
and that is because of the context of that judgment. Let's just look at the facts of this case now. So there was a date of 31 December 2025. So the suggestion is that if you now want to go to 31 March 2025, you must now do another notice and comment kind of a procedure and say, okay, I heard what you say. I will now want to take you to 31 March 2025. Give me your views. Then everybody is going to write to you with different views. And then, what if you then, at that point in time, agree with everybody that 31 March 2025 is not good? I must now decide on a new date. And now you want to decide on 30 June, for example. You must not go back and consult, because 30 June will not have been consulted on about, because that actual date will not have been consulted on, because we submit, my lord, it will lead to endless consultation. It's exactly what happened in electronic media case.
No, it didn't regarding 31 December 2024. It didn't lead to endless consultation. They actually reached the date. All of them, you've gone through the process. So your submission is not sustainable, I want to suggest, because we have an example where there was a consultation, and these parties were consulted, and they did. It wasn't endless.
Yes.
And that's what has led us to 3112. So you can't say it was going to lead to another endless. No, there's no need. But what happens, as is the situation, unless you are submitting differently, is that once that date has been reached, now we're getting submissions that it's impossible. It's an exercise in impossibility to achieve the impossible, to achieve the goal that everybody understands by 31st of March 2025. And there seems to be evidence to that effect, even from the implementer. And as we debate 31 March 2025,
Yes.
even the implementing agency is already saying, yeah, maybe this can be done in December 2025. So the suggestion that it's impossible to achieve comes out from the respondents themselves. We can't do it by the date of the ASO. Maybe we could achieve these estimates and so on by December. Even that is doubtful. Now, in other words, this whole point about consultation, it's not an exercise or in semantics or trying to just go through the emotions to say we have consulted. As I understand, you are saying the ETV decision was in a different context. Yes, it was. You are correct in that. But when the court set out the basics of consultation, the different context there, slightly different context, I must say, because it's still in the context of digital migration and issues concerned therewith, even in the ETB petition. So I'm saying the requirements are set to prevent this kind of, because maybe rather have some endless consultations in order to bring this whole matter of digital migration to a close in everybody's interests, rather than avoid consultations and then we come to a court and have to debate these issues that you didn't consult. And what is being extended? It's the major process, which even in terms of ETV is an important process for the country in all respects. And everybody's agreed about that this has got to come to an end.
Correct.
But if parties on the basics of achieving it don't do things like consultations, and then you come back and be debating, did you or didn't you consult? No, it was not necessary to consult, and so on. We're extending what even government may be concerned about, that this is the cost, costing country money. But what I'm saying, Mr. Tatawane, is that the first respondent, by avoiding, because this is what happened, they avoided consultation about the actual date. He knew it before going to cabinet. He had decided it. He was talking to the people. He said, what are your views about this? Because most probably, according to your submissions, they were going to say, no. You haven't achieved this in several months. Your rate of installing STBs is poor, to put it at its lowest. You're not going to achieve it in another 3 months. Let's give it a reasonable time.
Yes.
So I'm saying talking about actual date is not an exercise in semantics or going through the motions. It's to examine with all consent, including the implementer. Let's look at your record. Let's look at what is available in terms of STBs. Do you have enough STBs? Because then what we're talking about is just sorting out installers, increasing the number of installers to make sure that the rate of installation equals the months that we are going to agree upon. I'm talking to what these requirements are talking about, because then it becomes a dog, pardon the expression, chasing its tail. We've had rounds of this before. We're going to have other rounds, and it doesn't serve us, all of us, for that to happen. So this is why the court is saying, look, I can't really give you instructions about what to do, but the basics of consultation are going to be this. And then the main pillar of the implementation of this policy, being the first respondent, avoids it again. Isn't that what we have?
Well, one last important submission on this point. If it is correct that there was supposed to be another round of consultation during that December period, what will then have happened is that the minister will then have had to issue another notice in the Gazette, inviting people to make submissions on the date that the minister will have had in mind, let's say 31 March 2025. The minister will have prescribed a date within which, or on which people must submit their comments. the people who would have made submissions, they were not necessarily only going to be the applicants. There would have been others. And if they were going to prescribe a date or suggest a date, most probably they would have suggested different dates. And if the minister then decided to change 31 March 2025 and then pick up a date which no one has suggested in the written representations, then there's still going to be an argument that you didn't tell me about this date.
No.
That's the danger that we submit
Yes.
is likely to happen if that argument is upheld.
Yes, yes, I know we are treading in the realm of speculation because we're talking about something that didn't happen.
Yes.
But the risk of repeating myself, the basics that have been set down by the judgment to say these are the things that we'll consider: the actual date, the things that are done during this whole switch off process, if I can call it that, is to look, because it's been agreed that the STBs would be the alleviating factor. It wouldn't really solve everybody's problem. It would be the alleviating factor. Let's agree how we're going to achieve that. We've got an implementer. We have agreed about the process, what needs to be done, but let's make sure that this time around it's doable and that it's implemented. We might put aside other factors that have intervened. The closure of the post offices and failure of people registering, whether because of that, of less post offices or what, and other factors which have intervened the June 23 process is neither here nor there, but things have not happened as was agreed in the process which you outlined. So the discussion should take the form of this is what has caused the challenges that the first respondent has faced. Now let's address it. Now I confined it to the issue of STBs to say, are they available? How many people are we servicing? What's the period that is needed to do that? Do we have sufficient installers to do that? If not, what Centec is trying to do now, according to this new information that's coming through, is still to pursue a tender to increase the installers. And as the second applicant submitted, why are you doing that only now? That's the question in his address today. Why?
Well, that's Mr. Ferreira. I'll deal with him after this.
Well, but Mr. Tsatawan, I'm saying it's a legitimate question.
Yes.
To say these are the questions that you say, okay, this is where we are, installation rate so poor, you know, how do we deal with that? That's what they are interested in saying.
Yes.
In a realistic way, and that's what happens during the consultation. But Mr. Tsatawan, we're agreed, the actual date wasn't discussed.
Yeah.
And in the second point, as Mr. Marcus expands on ETV 3.2.2, it's about the issues that I've just repeated.
Yeah, those have been right.
That need to be done.
Yeah.
So that's the omission. And the omission doesn't help even the first respondent, doesn't help government, doesn't help the country. But I do not know if you want to make any further submissions in that regard.
Yes.
But I wanted to hear you if you have something different.
Well, one last point on that, my lord. I mean, all of these issues, my lord, which my lord is raising, one must always remember that what is sought to be achieved by a consultation process is not necessarily an agreement. And that's what the electronic media judgment says. And that's why
Yes, no. You're quite right on emphasizing that.
yes.
Because at the end of the day, even in the debate that I suggest should have taken place, the parties wouldn't necessarily agree on everything.
Yes.
On some aspects, they're going to say, no, let's not do it that way. Centec might come and say, no, for these practical reasons, let's do that differently. That's a given. That's a given. So it doesn't mean, as they like to say in a colloquial way, it's not my way or the highway. It's reaching a consensus to ensure we don't go down this road again.
Well, again, my Lord, with respect, the electronic media judgment said you're not seeking consensus in a consultation. You're seeking to give them an opportunity to give you their views. And we submit that the reason why we say they didn't have to get another round of consultation is because they've already expressed their views on all of these issues. But I think, my Lord, we have canvassed this.
Yes,
part.
we have.
Yeah. We have fully dealt with it in the summary and in the main as the first. The next 2 points in the summary, my Lord, relates to registration for set-top boxes. I think our submissions are clear and summarized. I don't need to take you through that. And the last issue in that summary relates to the rationality of the decision. There again, my Lord, we have made, we've given you a summary of the main points of our heads of argument, and we impress upon my Lord to have regard to that. Lastly, the point of the requirements for an interdict, the alleged violation of rights. That is dealt with in paragraph 6 and 7 of our main heads of argument. And the reason why we didn't summarize that is because you will kill me if I have to conduct a lecture on what the requirements are. We have canvassed all of that in our main heads of argument. The main point that we have highlighted is the consequence of the interdict that is sought. One, it is going to require funding, and the government has taken the decision that they are not going to fund this dual illumination anymore. And we submit that if you were to grant the relief that is sought, then there is going to be a separation of powers. We have addressed it in our heads of argument. I don't need to take it there. And then the second point, my Lord, is the...
But on that point...
Yes.
Is the first respondent not thin on the ground with regard to the 1.3 billion cost that he says is going to, or has cost government already?
No,
Well, it's not me saying so. The applicant are plucked from.
well, the government and Centec have been funding this. If you have regard to the letter from Centec, I'll give you the reference to it, 010-244. The issue of funding is raised in that issue, and I think in some of the consultation notes that I've already referred you to, a point is raised that the broadcasters are going to provide funding
Yes.
for that as well.
Yes.
But,
So wasn't this a joint effort? The broadcasters are also contributing to that funding.
well, they obviously pay a fee, but I do not understand anyone to be saying that they are making a contribution to dual illumination. But the applicants will tell you if they are doing that.
Yeah, but
But even if they were making a contribution, government's decision is that it is not going to finance it.
yes, in any way, according to the applicants, in this application, they haven't taken issue with that submission. So it's neither here nor there because they are not asking for any order from this court in that regard.
Correct.
So maybe your separation of powers, what's the name, is not yet maybe valid, but it's not necessary to address in this hearing.
Well, it is necessary because it goes to the balance of convenience requirement for the interim intellect. We have referred you to the outer judgment that says when you are faced with a situation like this, you actually have to be slow to grant an order that is going to implicate other organs of the state. In this instance, the executive will have to find money for it. Parliament will have to make the necessary appropriation if you were to grant the interdict that is required. And we submit that that does affect the separation of powers. In fact, there is a paragraph in our exit argument which we quoted from the outer judgment, where it was suggested that a government must just make provision for the funding. And the answer by the Constitutional Court was that simply saying that avoids the point that the harm lies in national government being obliged to fund a project that it has decided should be funded on the user pay principle. In this case, the government has simply not made an appropriation for it. The last point, my lord, relates to the integrity of the analog infrastructure that Centec is using. You have an impact assessment report by Centec, and Centec tells you, and everybody in the previous rounds of consultations accepted that the infrastructure is obsolete. It is old. Some of it was installed in the 1980s. It has passed its end of life date. It has passed its end of service dates, and Centec says there is a very high risk that this infrastructure is going to collapse. We submit that my lord should be very slow to grant an order which is going to require Centec to continue using a system which Centec tells is almost dead. There is an affidavit by the Chief Executive Officer of LS Communications South Africa which seeks to dispute what the minister says in the affidavit on that point. And the answer to that affidavit is a very simple one. That person does not say, I have conducted an assessment of that equipment and I'm satisfied that that equipment is still good to go for many years. Centec, the owner of the equipment, the operator of the equipment, says, I don't have reliable spare parts anymore to manage, maintain, and service the equipment. And if you order me to continue using it, you run the risk of it collapsing. And in the consultation documents, the broadcaster said they were going to take the risk of that obsolete infrastructure. But Centec tells you that it is not taking that risk. It just should not be done.
Well,
So,
if one is just submitted of the risks in the discussion that did take place, that were agreed were going to be taken going forward when we were still talking about 8112, isn't it? In that report that you gave about 23 June, that's one of the risks that we were going to take.
that's one of the risks that have been identified.
Yeah, and agreed.
Yes.
That we are aware that these possibilities, but then isn't this amounting to reprobation and appropriation on the part of Centec? Because it's the implementing agent.
Yes.
They procured STBs from time to time, not adequate as agreed. Right now, as we speak, they are presiding over a tender to increase installers the number of which was clearly far from adequate. And the installers are installers of STBs. And Centec gives the estimate, crystal balling into December 2025. It is the technical implementing agents. It's reading that crystal ball that we will achieve it by December and so on.
Yes.
So that's approbating and reprobating, because let's say they've given the warning that this technology is going down, it's not on the up. But
I actually think it's very down.
well, yes, for me and you to speculate about that, yes, but let's just accept that it's being seriously said by Centec that it's going down, and maybe, but everybody agrees, they accept. And it itself is saying by December we'll still achieve. So that's why I'm saying it's not really down, because it wouldn't engage in that kind of contract of increasing installers if at all it was down and out.
Well, madam, the installers are coming in to install the STBs. They are not going to work on the infrastructure which Centec says is obsolete. Yeah, so there's no approbating and reprobating there.
No, but the STPs must be available from the infrastructure that produces the STPs, isn't it?
Yes. Well, my last submission on that point is obviously that in as much as the other people are saying they are prepared to accept the risk, my Lord obviously knows that my Lord is not only looking at the interest of the applicants here. My Lord is looking at the interest of the whole country,
Absolutely.
which is relying on the analog infrastructure.
Yeah.
And Centec says, let's forget about it. It's not reliable. When it breaks down, the original equipment manufacturers are not going to give me spare parts. I don't have reliable spare parts for it. At the moment, as we said in our papers, if one of these transmitters runs into difficulties, you can work on the basis that used spare parts are going to be used to try to fix it. That we submit, my Lord, is just undesirable.
Yes.
Those are our submissions.
Thank you. Thank
So
you,
we'll
Mr.
ask
Secretary.
my Lord to dismiss the application. The Constitutional Court in ETV said this is a constitutional matter. The BioWatch principle applies, and we can't question that.
Thank
As
you.
it is the court.
Thank you, Mr. Secretary.
Sorry, my Lord, they still just movement
Yes,
of,
yes, no, that's an order.
they just,
That's an order. Mr. Marcus, are you ready?
Yes, my Lord. With your Lordship's leave, my Lord, my learned friend Mr. Duplessis will duly reply.
Oh, thank you.
Thank you, my Lord.
Thank you, my lord.
Thank you, Mr.
My lord, we say this with respect to our learned friends. We've listened to them arguing, and their entire case really amounts to the studious avoidance of the findings by the Constitutional Court in a binding decision which is on point in the ETV matter, and which tells my Lord who must take the decision. It tells my Lord what must be consulted about, and it tells my Lord what the rational objective is that's to be achieved by the determination of an ASO date. And with respect to our learned friends, the evidence before my Lord makes the case easy. And that is because of two principles on the evidence that have been established by the Constitutional Court. The first principle, my Lord, is paragraph 78 of the ETV judgment in the Constitutional Court. And my Lord has got it from our learned leader, Mr. Marcus's note. I'll paraphrase for you, my Lord. Paragraph 78 says that the central purpose of the ASO, this is the Constitutional Court, is to mitigate the adverse impact of switch-off. So the purpose behind setting the determined date is to mitigate the adverse impact. And my Lord, that can only be done. You can only mitigate adverse impact if you consult with those that are able to tell you about the impact and are able to give you that input. A point I'll come back to. And secondly, my Lord, that is why the Constitutional Court in paragraph 78 went on. It said, if you as the minister want to determine a set date by which you'll switch off, as the minister, for you to rationally do it, you have to know how many people are going to be impacted, and you have to have done in your process an analysis of the particular impact adversely upon these are the words of the Constitutional Court, millions of indigent persons whose currently working television sets will be rendered useless. Now, my Lord, that is the first principle. I'm going to reference it as the paragraph 78 ETV principle for the evidence. There's a second principle, my Lord. It's the Moise Necro principle. You heard it from our learned friend, Mr. Ferreira. Government, when rights are impacted, here they are, my Lord, in 2 weeks' time, over 1.2 million people's rights go dark. Well, my Lord, you as the government have to produce evidence to show why that limitation of rights is justifiable. It's a heavy burden. It's a burden borne by the state. And my Lord, we say in this case, as our first point in reply, that the case is easy for you, my Lord, because the government has failed both those evidentiary requirements in a startling fashion. They've done so in three ways. My Lord, in relation, firstly, to MMA and SOS, they've come in the public interest. They've explained to my Lord in the affidavits that they filed as separate applicants what the Constitutional Court in ETV said about the impact on the indigent. They set out, my Lord, in their affidavit, the impact this would have on the SABC as the national broadcaster. And my Lord, they set it out in detail in case lines 003-21 as to the impact on the SABC, which they described as catastrophic, and they explained why. And my Lord, they set out the impact on community broadcasters at 003-25 onwards. And my Lord, here's the important point. There is no answer at all to the minister, from the minister to that affidavit. The minister's answering affidavit deals only with ETV's affidavit. Our learned friend, Mr. Ferreira, generously suggested that there might have been an oversight by the minister. Now, my Lord, the minister is not entitled to an oversight. The minister is represented by senior counsel. It is not, in the words of Kurland, a bewildered litigant, adrift on a sea of confusion. And, my Lord, so it elected not to answer those aversions as they stand uncontested. They're important, my Lord, because of something that has happened this morning. It's the SABC, which has filed an affidavit. And, my Lord, it's important for my Lord to have regard to that affidavit. If I might hand up a copy, I think there's been hard copies that have now been made available, and they're on case lines. It's 007-1, where you now find the SABC's affidavit. And my Lord, it's important for ETV to make its position clear. We do not oppose the SABC providing the affidavit to the court, my Lord. With great respect, it lies ill in the mouth of the minister to complain about SABC's attempts to assist the court with an explanatory affidavit in circumstances where the minister treated us all to what was yesterday its belated effort to file an affidavit. My Lord, you need the evidence in order to properly come to a view on ASO. And my Lord, let me show you why in the SABC's affidavit it is critical for you to have regard to what they say because of the uncontested evidence, as I've said to you, my Lord, that you've already got in MMA and SOS's affidavit, which the minister didn't answer. Because what the SABC says in this affidavit, my Lord, chimes with exactly what MMA and SOS described as the catastrophic impact that lay ahead for the SABC. My Lord, if you turn with me to paragraph 20 in the affidavit, 007-10. Lord, you'll see there, this is what the SABC says in its affidavit. It says, the premature analogue switch-off in the above-mentioned 5 provinces resulted in a major loss of audiences and revenue to the SABC. I refer the court to Annexure NC3, which reveals the SABC's loss of audiences and revenue. These losses have been detrimental to the SABC. Likewise, the analogue switch-off gazetted to be effected on 31 March 2025 will further jeopardize the SABC's sustainability. That is the national broadcaster telling you, my Lord, that their sustainability will be jeopardized in 2 weeks' time when the switch-off happens, particularly in light of something my Lord pointed out to my learned friend. There is no answer from the minister to its mistake of fact about the 5 provinces that it said and Centec thought had been switched off. We've heard not an answer. That mistake of fact resonates throughout these proceedings. I'll come to it in a moment. But what the SABC is telling you here, my Lord, is that in respect of those 5 provinces, there is a critical difficulty for the national broadcaster that will jeopardize its sustainability. Now, my Lord, have a look, if you will, at the letter that is attached. It starts at 007-15, NC2. It's a critical letter, my Lord, and that's why, with great respect, the minister should not be attempting to object to the admissibility of this affidavit. This is a letter you'll see in the covering heading to the minister. Dear Honourable Malatsi, the Minister of Communications and Digital Technologies. My Lord, it's a letter from the 3rd of December 2024. So there's no debate at all that the minister knows of this letter. It was written to the minister personally. And it expresses, my Lord, the following at paragraph 13, 007-17. It says this. In other words, and I do need to read it, my Lord, because of its importance, the implementation of the ASO on the ASO date, 31 March, will culminate in millions of South Africans being left without access to the South African Public Television Broadcast Service. The current slow pace of set-top box installations with an average rate of 16,000 units per month illustrates the country's unreadiness to complete the outstanding installations required to ensure a seamless migration for millions of households. This extremely slow pace of registrations, procurement, and installations of set-top boxes stands to shut down indigent communities from access to public television broadcasting. As you're aware, these indigent communities rely solely on analogue transmissions for access to information, education and entertainment. And additionally, our experience with the already analogue switched-off provinces presents the SABC with a worrisome trend of declining audiences and revenue losses. 18. Undoubtedly, this will jeopardize the corporation's financial sustainability and its legislated public mandate. And 19. Due to the challenges highlighted above, the SABC hereby reiterates its request for an extension of the analogue switch-off date by at least 12 months, in other words, to 31 December 2025, to ensure the seamless completion of the entire migration process. My Lord, as I say, this letter was from the SABC to the Minister. It is a letter that interestingly, my Lord, and we say disturbingly, was not disclosed or put up in the minister's affidavit.
What's the letter there? The letter?
Yes.
NC2.
NC2, my Lord.
NC2.
It's Annexure NC2.
Thank you.
That letter, my Lord, was not put up by the minister in his affidavit answering ETV's case, or to the MMA SOS affidavit, in which it had been expressly said that this was also going to negatively affect the national broadcaster. That letter was known to the minister. The minister knew that the SABC was drawing this as very serious concern to his attention and was asking to extend beyond 31 March 2025, and there was no indication that it was in any way taken into account at all, my Lord, and was not made available to the court. Now, my Lord, that is not just a breach of the relationship between the SABC and the minister. It's a breach of the minister's duty to this court of candour to explain to the court that this is what the national broadcaster was saying to me on the 3rd of December. This is the calamitous consequence that will arise for the national broadcaster who've written to me on this basis. Now, my Lord, there's one final aspect of that letter I must draw to your attention, because it goes to the point. You've been debating with my learned friend about whether it was the cabinet that took the decision or the minister that took the decision. Now, my Lord, have a look at 007-18. That's that letter, paragraph 24.
007.
-18, 18, and it's paragraph 24.
Yes.
My Lord, it says this: therefore, by this correspondence, the SABC board seeks, over and above the requested extension period for the ASO, written confirmation from yourself to officially confirm Cabinet's decision to proceed with the date as gazetted, and then, importantly, 24.1, whether Cabinet took the serious concerns raised by the public television broadcasting industry into account when taking the aforesaid decision, and 24.2, whether Cabinet took the serious concerns raised by the public television broadcasting into account when taking the aforesaid decision of proceeding with the ASO date as gazetted. So whether it's as when you gazetted or as when you took the decision, we want you as Cabinet to confirm whether you actually took these serious concerns by the SABC into account. I say that, my Lord, it's a very important point, because I say the next important feature of the evidence, the second important feature of the evidence, is the following. I've told you, my Lord, there's no response to MMA and SOS. And as a result, we've now seen the danger of that because of what the SABC's told you was going to be the calamitous consequence for them, confirming what MMA and SOS's uncontested evidence said. But the second problem is, my Lord, there's an affidavit in this case only from the minister. And the minister comes to my Lord and he says, Cabinet took the decision. And the minister tells my Lord that Cabinet took the decision, yet there is no affidavit from Cabinet. There is no affidavit from the President. And here, my Lord, there is a promise that was made by the minister. The minister said that the minister would provide, through a filing by the President, the reasons for Cabinet's decision. My Lord, it's paragraph 25 of the answering affidavit. 2.5, I'm sorry. Answering affidavit, case lines 010-9. My Lord, and I do need to just read it for my Lord again. I think Mr. Marcus may have read it to you, but if you'll forgive me reading again because of the importance of the point we need to stress. This is what the minister said at 2.5. Whilst the decision to proclaim the ASO date was taken by the Cabinet, it was briefed by the minister on the process that was followed up to the date on which the determination of the analogue switch-off date was made. And then the important promise. For this reason, the President of the Republic will also be opposing this application and will inform the court, obviously by affidavit, of the basis on which the government opposes the relief which the applicants seek in this application. Now, my Lord, that undertaking, that promise, was directed, no question about it, in its affidavit, because of the point that the minister took, which is, I didn't take the decision, Cabinet took the decision, and don't you worry, court, don't you worry, applicants. The President will inform the court of the reasons that Cabinet took. There's been no such affidavit. And that is a startling failure. My Lord, for a very simple point, and I won't bore you with the old case law. You all know it, my Lord. Gerhardt versus the State President. Lordship, Mr. Justice Goldstone said it, my Lord. One person cannot make an affidavit on behalf of another. So the minister can't have made an affidavit on behalf of the president, and he knows that because he promised at paragraph 2.5 that he would get the president to put one in to explain the reasons for Cabinet's decision. Nothing, my Lord. So, my Lord, what does that mean? It makes the case easy for my Lord. There is no idea. Let me just pause before I go further. This is on the assumption, for a moment, accepting that Cabinet could take the decision. We don't accept that for the reasons we've already heard from my learned friend, Mr. Marcus. We say, for the reasons that the Constitutional Court in ETV stressed, in paragraph 35, the minister must take the decision. The minister must determine the ASO date. Let's assume for a moment that our learned friends are correct for a minute, and that Cabinet, through some amorphous understanding of Section 85 of the Constitution, could take the decision. Well, my Lord, then you're in a worse position for our learned friends, because you've got no evidence before you. What did Cabinet take into account? Who did Cabinet consult with? Why did Cabinet think 3 months was reasonable? And my Lord, you know why critically that evidence should be before you? Because we know on the available evidence that Cabinet took this decision overnight on a meeting on the 4th of December. You'll know from the papers, you've read them, my Lord. The 4th of December, Cabinet had an emergency meeting. Remember, on the 28th of November, they said, we're not extending, we stick with 31 December. My client ETV wrote and said, that's just insensible and irrational, you need to extend. And as a result of that correspondence, Cabinet met on the 4th of December, overnight, and the next day, the 5th of December, was the announcement. All right, we relent. We're now extending beyond 31 December for another 3 months until the end of March. So, my Lord, that one-night decision-making process, you have no evidence of. And it was critical for it to be placed before you. My Lord, so that's the second problem on the evidence. The third problem, my Lord, on the evidence arises from what happened yesterday. It's the minister's belated affidavit. My learned friend, Mr. Marcus, said that the position today, in light of that affidavit, my Lord, hasn't changed at all, because really it's just a smaller number that the minister now says Centec is chasing to achieve. But with great respect, my Lord, the affidavit makes things remarkably worse for our learned friends because of the obvious things it doesn't tell you. My learned friend, Mr. Marcus, highlighted there's no plan. So this affidavit was a chance for the court to come for the minister to come to court to say, we know there's a debate about what it is that we were doing. We didn't give any reasons as the president's affidavit had been promising. We're taking a chance, quite frankly, to file a belated affidavit. But we're at least going to help the court by explaining to the court what it was that our plan had originally entailed before the decision to extend to 31 March. Didn't do that. We still have no plan, nothing. Or, to the extent that it wanted to convince my Lord that there is going to be a rollout to meet the end of December 2025, here is the plan. But it doesn't put it up, my Lord. Now, my Lord, in discussion with my learned friend, Mr. Ferreira, in this context, you said, well, I really am only worrying as the court about the next 2 weeks. How many people are going to be cut off in the next 2 weeks? And my Lord, that is correct. We, with respect, agree. But my Lord also will want to know, if you do not grant the interdict within the next 2 weeks, what will the continuing impact be on people's rights over the next months towards the end of December? Because an interdict is obviously meant to stop harm. What is the extent of that harm? My Lord, our learned friends for the minister had a duty under Nikro and Moise to tell you, we know we're cutting off people's lights and television. We know they're going to go into television darkness. But it's not going to be deleterious in a manner which is severely inflicting pain on them for too long, and we're going to be able to remedy this violation as quickly as possible because of this plan. That was their duty under Nikro and Moise, but they didn't give you the plan. So we sit here, my Lord, without any plan. What we have, the only thing you have on the evidence, my Lord, is the plan that Centec put up 2 weeks ago. And it's in the record, or case lines 01195, my lord. And it's a plan that talks about, and this is a plan, my lord, from the end of February. So just a couple of weeks ago. And it's an installation progress plan. This is all you've got before you on the evidence. And it shows you the plan for December and for January and for February. And it shows you what the plan is, the actual. So there you see what Centec plans and what it actually achieves. So, my lord, in December, it's working with very low numbers. It says its plan is to roll out 7,000 boxes. And it achieves a bit more than that, my lord. It achieves 8,646. But then look at January, my lord. Its plan is to roll out 25,500. What does it achieve? Its actual, my lord, 10,293. My lord, February, its plan is to roll out 51,000 boxes. 51,120 boxes. Actual, it rolls out 8,486. And it tells you at the bottom of that page that the impact of this low rollout plan versus actual is due to the following, my lord. This is of 2 weeks ago. Poor quality of beneficiary registration data. Inclement weather challenges. An installer appetite to undertake work in rural areas due to the below market fee. So, my lord, in the absence of our learned friends giving you a plan in their affidavit that they filed belatedly last night at 6 o'clock, all you've actually got, as contrasted with their paragraph where they say through Centec, don't worry, we have accelerated plans. We will make sure that the rollout takes place by the end of December 2025. What you have, by contrast, is that Centec statement of just 2 weeks ago, which tells you why, and our learned friend Mr. Ferreira said it, on Webster versus Mitchell, it's a question of what are the probabilities. Oh, my lord, the probabilities count so heavily against our learned friends on that very document that it was incumbent on them, a moise necro duty, to give you their plan, to be candid with the court, to explain how they were going to overcome those significant deficiencies. My lord, I can deal very briefly with the last 2 points. The first is the issue of ETV's commercial interest, and I do need to correct it, my lord, because it's simply wrong to continue to beat this drum that somehow ETV is here for its commercial interests. My lord, of course it is. It's a commercial litigant. It's allowed to protect its commercial bottom line. But it says emphatically, and Mr. Marcus took you through it painstakingly, that it also has public interest duties cast upon it as a license obligation. It has to broadcast in a public fashion. It is a free-to-air television broadcaster. It does so, my lord. It's set out in Mr. Marcus's note at paragraph 1.3 and 1.4. And our learned friend read from the ETV judgment, my lord. But he didn't, with great respect, and it's important to read to you what is said at paragraph 102 of the ETV judgment. It says this: while these submissions bear consideration, it must be noted that this court is not called upon to make a pronouncement on ETV's intentions in bringing this application. This court is required to objectively consider the rationality of the decision taken by the minister. That's the only issue in determining the ASO. This exercise was supported by the submissions of MMA and SOS, two non-profit organizations with no vested commercial interests who act in the public interest. What is the court telling you, my lord? That ETV is making arguments which chime with MMA and SOS, who are in the public interest. And the Constitutional Court endorsed that approach. So we, with great respect, we take some umbrage at the repeated suggestion of commercially driven interests. Then, my lord, let me say something very quickly about Centec.
Well, there are only two free-to-air broadcasters
Indeed.
that are broadcasting on the analog spectrum,
Indeed.
isn't it? So
Indeed.
that's not challenged.
No. And my Lord, and what we've got is the situation where, by virtue of what I've read to you from the SABC's affidavit, we know what the impact is. It's calamitous. It will be that consequence for the national broadcaster. And ETV is entitled to be concerned about that. And it says to you that it is also concerned about the indigent. It's allowed to be concerned about the indigent. All of us are. So, my Lord, that's the commercial point. If I might quickly deal with the Centec point, because our learned friend has tried to raise some other concern around Centec and the fact that there might be problems with transmitters and that there's a very old network. My Lord, but that's been the position for years. We haven't seen the minister desperately trying to hurry up and get set-top boxes out over the last year because he knows that there's a problem with the network. If he was truly convinced that there was a problem with the network, we would have had ASO finished. But there's the second point, it's my Lord's point that you put to our learned friend. It's internally inconsistent because Centec itself tells you in the affidavit they filed last night that they are rolling out and they want my Lord to take account of their rollout over the next 12 months on that very network. And my Lord, of course, the counter is this. What they're really telling you is they prefer for my Lord to be in a situation where you sit with this problem of the network, but if you listen to them, they don't want us to get the relief that we're seeking from my Lord. In 2 weeks' time, my Lord will effectively, if you don't give the interdict, you will allow switch off to happen immediately for all of those people. So there's the risk of, well, the collapse of the network might take place versus well, if you don't grant the relief that we're seeking, all of those people will definitely be switched off in 2 weeks' time. So, my Lord, when you weigh the risk, it's obvious. The interdict can be granted. My Lord, finally, and very briefly, because I think it's the important point on consultation, I do need to just say something briefly about this. My Lord has already highlighted that, of course, it's not consultation as a semantic exercise on a particular date. It's not about that. The consultation is to achieve a purpose, and that's why I started my address by saying the Constitutional Court, in its judgment in ETV, said the minister must know what the impact is of the ASO decision at that time on these people, given the facts of how many set-top boxes, where are they, what contracts are being concluded, what are the networks like, what is the weather likely over the next couple of months, where are we in terms of finalizing warehouse stock distribution, what are those types of facts? That's what the Constitutional Court said are the critical features of the debate. And my Lord, our learned friend repeatedly read to you from the e-media judgment. But he didn't grapple with the two paragraphs, never grappled with the two paragraphs, which my Lord was effectively putting to him. Paragraphs 47 and 48 of the Constitutional Court's judgment in ETV, which deals with this very thing. The Constitutional Court said this, my Lord, if I may paraphrase it again. In her submissions, the minister continues to hold the stance that she wasn't required to consult because she'd had numerous meetings on previous occasions. The minister submits that although she wasn't required to do so, she consulted with ETV and other broadcasters regarding the ASO date, and the minister highlights that ETV was offered numerous opportunities to make submissions on the proposed analogue switch-off date and plan. Important point at the end of that paragraph, my Lord, says the Constitutional Court. It bears noting, however, that there is no mention of similar consultations with MMA, SOS, or other similar interested groups. I pause to take you back to my point I made. There's no contest. When MMA and SOS in their affidavit, which has not been responded to, say, we were never consulted about any of these dates. We were not asked a single thing about this. That is exactly the same point that the Constitutional Court was worried about there. But, my Lord, then the Court goes on at paragraph 48, it says, the minister refers to several consultations that took place leading up to the 2008 BDM policy to suggest that proper consultations were undertaken before the consultations that took place during the preparation of the BDM policy. Says the Court, they are not equivalent consultations to determine the analogue switch-off date, which would involve different aspects than consultations in preparation of the policy. And then the Court says exactly what I was paraphrasing earlier, my Lord, and I'll read it to you because it really is the end of the answer, or end of the debate with our learned friend. Says the Court, for example, critical questions raised in consultations before the analogue switch-off date would have sought to determine the number of persons who qualify who would like to register for set-top box before the ASO switch-off date, how long it would take, at the current rate of installation, for all the households that wish to register to receive set-top box to be supplied with such. Finally, on this point, my Lord, on consultation, our learned friend made, we say with respect, a remarkable submission where he says, well, we didn't have to renegotiate. That's not a word that ETV used, my Lord. That's a word that appears in the minister's summary of the meetings that we had. But he goes further to say, well, there was no need to hear us on any of these aspects. We didn't need to hear you because everything, these were his words, I wrote them down, everything that could...
To hand up the witnesses' 204 statement, if I can just prove that.
Certainly, you may do that.
Thank you.
We've had W earlier on, so this will be X. You can just take it through it.
My Lord, I have 2 copies. I thought of giving one to the witness and one to the interpreter.
Yes, thank you.
Unless my colleagues for the state would give your lordship a copy.
Because they will give me the original to mark. I think I will just take a copy as you go through, then I can see the signatures, etc. This is the original. Thank you.
Thank you, my Lord.
Let's make it easier. Let's make it easier. Ms. Lombard, were you given a copy of this statement before you started testifying?
Mevrou Lombard, was u hierdie verklaring gegee voor u kom getuig het?
That's correct, my lord.
Yes, my lord.
Just have a look at the document that's now shown to you, whether it's the same one that you received.
Kan u dan die dokument kyk wat voor u is dit dieselfde dokument wat u gekry het?
That's correct, my lord.
That's correct, my lord.
And I see it signed on every page, as well as the end of the statement, and it indicates a preamble that you were assisted by an advocate, Eben van Tonder, in preparing the statement.
Ek sien op dit is geteken op elke bladsy en advokaat wat u bygestaan het is Eben van Tonder.
That's correct, my lord.
That's correct, my lord.
And you confirm the correctness of this statement, it being yours.
En die inhoud wat in hierdie verklaring staan, dit is hoe u afgegee het.
That's correct, my lord.
That's correct, my lord.
Marked Exhibit X.
Is for Sierra, my Lord. X. X. Thank you.
The last one is W, so this one will be X.
That's true. Thank you.
It has called a waarskuwingsverklaring afgeneem van 'n persoon wat haar bereidwillig verklaar om in terme van artikel 204 van die strafproseswet, wet 51 van 1977.
Exercise is by the government's failings being egg on their face and a slowing down of the process, which everybody in the country wants to have accelerated, but constitutionally so. And for those reasons, my Lord, we say our learned friend has simply not grappled with the importance of the ETV Constitutional Court judgment, and he hasn't grappled with our arguments in that respect. And we therefore continue to submit that the application should be granted, and with the cost of 3 counsel, as my learned friend Mr. Marcus highlighted. My Lord, unless there's anything else, those are our submissions in reply.
Thank you.
Page 18.
date the postponement would be to, because he accepts that there was never any consultation about the date of 31 March 2025. The difficulty for our learned friends is that is fundamentally at odds with what the Constitutional Court held in paragraphs 48 and 51, where the Constitutional Court said that what must happen in this specific context, not in relation to the encryption fight in a different case, in this specific, the exact same case, which Mr. Marcus and I were in last time and our learned friends for the Minister were not in, what the Constitutional Court said is that what you have to do is consult about the specific date that you are considering. And the reason for that is clear. What the Minister had to say was, I'm thinking about postponing to the 31st of March 2025. What do you have to say about that, interested and affected parties? And if he had done that, my clients would have been able to say, we have looked at the installation rate. We have looked at what is happening on the ground. It seems to us that 31 March is still going to result in at least 1.2 to 1.5 million people being plunged into darkness. It is too soon, given your own rate of installation. But he never does that. He never hears representations about that date. Instead, he just decides on the 5th of December that it's going to be pushed back by 3 months. But my Lord, why is 3 months considered rational and reasonable and appropriate for this postponement? Given that a 3-month postponement is still going to result in 1.2 million people being plunged into darkness. And it's astonishing that we stand here and no one has attempted to justify that 3-month postponement. No one. No one tells you it's reasonable and justifiable because we think we'll be able to increase the speed. There's just no attempt to say 3 months is a rational decision. Not from the Minister, but least of all from Cabinet, who we are told actually took the decision. Cabinet just seems to have thumbsucked that 3-month postponement out of the air, without any notice to anyone, without any consultation of anyone, and no attempt here to justify it. So we say too on the consultation point, this is essentially a case which is uncontested on the Constitutional Court judgment, and one where irrationality and unlawfulness is conceded. My Lord, I want to make some brief additional submissions about the letter which the SABC attaches to its affidavit and which Mr. du Plessis took the court to in a bit of detail. It's Annexure NC2 to the SABC's affidavit. That is a letter sent by the chair of the SABC to the Minister personally on the 3rd of December 2024. In essence, it confirms everything that MMA and SOS have complained about. It says that the ASO date will have disastrous consequences for the public who cannot afford decoders. That's paragraph 8 of the letter. It says if it is implemented, it will force the SABC to contravene its statutory duty to provide universal access to free television. That's at paragraphs 10 and 11. It says that implementation will result in millions of people losing access. That's at paragraph 13. And, my Lord, it doesn't just make these assertions in the air. It tells the Minister the SABC knows this to be the case because of its experience in the 5 provinces where the SABC has already switched off its analog transmitters. And what you see from the annexure which follows the letter, NC3, on the first page of that annexure, is that the result of switching off the SABC's transmitters in those 5 provinces is that, comparing financial 2020 to financial 2023, SABC 1's viewership declined by 57%, SABC 2 by 59%, and SABC 3 by 61%, largely attributed to analog switch-off. And so the SABC tells the Minister we have had experience of this analog switch-off without adequate migration happening. And what it says in paragraph 23 of its letter is that the consequential audience and revenue loss pursuant to the ASO date shall spell the demise of the 88 years old South African Broadcasting Corporation. Now, my lord, we make two submissions about that letter. The first is it supports everything my clients have always said about analog switchover. The second thing is Mr. Du Plessis already submitted that it is surprising that the minister chose not to put that letter up himself in discharge of his duty of candour to this court. But we say it's actually worse than that, my lord. Because not only does the minister not put it up, his affidavit deliberately obscures the true position, and we would submit skates dangerously close to seeking to hide evidence from this court which is relevant. May I explain why with reference to the pleadings? My lord, at page 002-88, that is paragraph 199 of ETV's founding affidavit, the deponent says the following: I understand that the SABC would suffer similar, if not worse, financial consequences, given that it is estimated that the SABC would lose a significant portion of its viewership, between 25% and 32% of its audiences, for channels currently must be accessed its transmission via analogue, particularly in the larger provinces if ASO is allowed to occur on 31 December 2024. This is confirmed by the chair of the Parliamentary Portfolio Committee, who explained that ASO on 31 December 2024 will mean the demise of the SABC. That's what is pleaded about the impact on SABC. The minister then deposes to an answering affidavit himself, and he answers to that paragraph. And the answer comes at page 010-135, at paragraph 18.27. And this is what the minister says, my lord. He says, the contents of paragraph 199 are denied. There is no direct evidence placed before this court by the SABC itself to substantiate that which is alleged in paragraph 199. In the premises, the contents of paragraph 199 ought to be rejected. The SABC is not going to collapse if the relief which the applicants seek in this application is not granted. Now, my lord, that is extraordinary. The minister deposes to that affidavit at a time when he is in possession of the letter from the SABC, which tells him, indeed, you are going to bring about our demise if you implement ASO on this date. And not only does he not put that letter up, he fails to disclose it, he deposes to an affidavit which contradicts it without any basis. And my lord, we would submit this is conduct of the litigation which is deserving of the most serious censure of this court, and at a very minimum, we submit this should weigh heavily with this court when this court exercises its discretion as to costs. And we would submit that on its own, it merits a punitive costs order against the minister. My lord, and finally, simply to confirm that my clients also obviously do not object to the admission of the SABC's affidavit. It plainly ought to be admitted on the same basis that the minister's affidavit of last night ought to be admitted. My lord, thank you. Those are our submissions in reply.
Thank you, Counsel.
As it pleases the court, my lord.
Yes, Mr. Mureko.
Yes, I don't know if the only issue that is outstanding is the admission of the SABC's affidavit in light of the minister's objection to that affidavit. I don't know if we should deal with that after the adjournment or we should deal with it now.
No, we are almost at the end of this hearing.
As it pleases the court.
I was intending to deal with those two affidavits which were submitted belatedly. When affidavits are filed as late as they did, as these two affidavits were filed, you may sit down, Counsel.
Oh, as it pleases the court.
They're usually accompanied by an application for condonation. But I have considered the matter and the issues that sought to be addressed by those affidavits, and it's not an issue that calls for technicalities to be considered by this court. If the affidavits sought to be filed give a better understanding of what we are trying to solve in this hearing. And on the basis of interests of justice, I therefore accept that these two affidavits be accepted in the form that they've been filed. And I say that even though counsel were not arguing the admission of the affidavits, but they were arguing the relevance of the contents thereof. So I am certain that they would assist this court in coming to a just conclusion regarding this matter, and that's the basis for their admission, and they are admitted. Thank you. I don't think there is any other issue outstanding, and I must thank counsel for their addresses to this court. They've been clear and succinct, and they stuck to the time that they'd been allocated, and a judgment will be handed down in due course. I'm aware that due course means in not more than 10 or 9 days' time, but I assure everybody I'll do my best to do so. Court adjourns.
Thank you.